I'm going to turn it over to Margaret Johnson, who will do the intro for our speaker today. Margaret is the chair of the gun practice section. All right, good afternoon and welcome to the review of attorney disciplinary cases in 2016, presented by Roger Kuhl. He's Assistant Polk County Attorney. Roger is a graduate of Drake University Law School, where he got his Juris Doctorate, and of the University of Dubuque. He was admitted to practice in 1972. He's currently the first Assistant Polk County Civil Bureau Chief. Previously, he was a claims counsel for Polk County from 2005 to 2015, at which time he defended all civil litigation and workmen's compensation cases. He was in private practice from 1972 to 2005 with an emphasis in civil litigation, civil rights and employment law, and attorney disciplinary work. He has lectured on attorney professional ethics, civil rights, law enforcement, and detention issues. We want to welcome Roger today for our presentation. Thank you.
Thanks, Margaret. We're going to have a large number of cases to review today. If you look at your slides, you'll see that there are actually I've lost my projector. Here we go. I'm going to be referring to cases that the disciplinary board of the Iowa Supreme Court has brought. You'll see references to the board, that is the disciplinary board, and the commission, which is the grievance commission. Both of these bodies are appointed by the Iowa Supreme Court pursuant to court rules. When you go through the cases, reading them, you'll see that the cases almost always involve violations or alleged violations of the rules in Chapter 32 or the attorney trust account rules in Chapter 45. There could be violations under Chapter 602, the code as well, but generally everything's picked up under those two rules. So in 2016, there have been 13 attorney disciplinary cases, 3 judicial qualification cases, and a relevant certiorari case issued by the court. You can see in previous years there have been more disciplinary cases. And if you go back before 2010, there were frequently as many as 25, 26. This has been attributed in some corners to the fact that the board now has more authority to dismiss cases or complaints early on that, in their opinion, don't warrant going through the full disciplinary process. I'm going to try and go past the judicial cases and just concentrate on the disciplinary cases. Then I'll come back to the judicial cases if we have time. They're actually not only interesting, but a couple of them relate to the practice as well. So the board acts like a grand jury when it investigates a complaint, and then if there's a case that goes to the grievance commission, the board acts like a prosecutor. The commission is the fact finder. It recommends sanctions to the Supreme Court, ranging anywhere from a reprimand to a revocation if it finds violations. It can issue a private admonition, which does not become public. The court, of course, reserves the power to decide the appropriate sanction, even if the board and lawyer stipulate to a sanction. Frequently, there is no appeal at all from the commission's report, but because the court reserves the right to make that final decision, it can give the parties an opportunity to argue their respective positions on a final disposition. So the first case in February involved a lawyer by the name of Doe, and it's Doe because there was no public discipline, but the court felt this case was important enough to publish. So Doe was licensed in '98, but he never practiced, and his license actually was inactive through 2011. But he became a litigant and hired his own lawyer in 2007 for his employment case. He got into a fee dispute with his lawyer. The case went to the local arbitration committee. He was asking for a $25,000 refund. The committee gave him a little over $3,000. He appealed that to the district court, and the district court upheld it. But Doe felt that the court was a little too collegial with the committee members in the hearing, and he asked for a reconsideration. Although the court denied the motion, and before the time it was up to appeal, Doe, 12:30 at night, sent a very scathing email to the judge. I'm going to read that to you. Some might find this humorous, some might gasp, but in any event, he wrote, "Dear Judge Hutchison, like I stated in my motion to expand and correct your pathetic ruling, I never communicated with you ex parte until now. Because you chose to play fast and loose with your ethical responsibilities and irresponsible rulings, please accept this as your first ex parte communication from me. The rest, you unethical behavior, you can explain to your Judicial Committee. You should be ashamed of yourself, and I'm sure you have heard this before. Your shameless cover-up for your circle of buddies will not go unaddressed. However, hopefully, I never have to deal with your arrogant, unethical behavior again." And he went on. Well, as you might imagine, the judge sent that email to the board. Fast forward 2 years later, Doe decides to activate his license. Within a week, the board filed a complaint with the committee about the email. So the commission held a hearing. It found that he had made false statements about a judge in ex parte communications and recommended a public reprimand. They were quite split on that decision. There was a question whether or not Doe was really a lay person without an appreciation for the rules governing lawyer conduct. The court gave a private admonition, thus it's John Doe and not whoever this person is, but they gave the private admonition reasoning that there really was no interference with the administration of justice because there was no need for a rehearing or filing of additional paperwork or continuances or that kind of thing. But it was an ex parte communication, and that led to the admonition. Doe actually complained that his First Amendment free speech rights were violated because he should not have been disciplined for writing that letter. The court found, however, not a violation of the Constitution because it was not objectively reasonable to believe that the judge was involved in a cover-up. So the court gave his opinion in order that we members of the bar know what the proper communications are with the bench. Don't use that letter as your typical judge communication. The next case, also in February, involved Jamie Deremiah. He had a problem with the girlfriend that got into a fight with her. He was charged with domestic assault with bodily injury. The case involved a situation where they had been out in an evening. They were doing some heavy drinking. They went their separate ways but got together later at her home. A fight ensued, and she actually got injured, not terribly, but she had injuries, and they were well documented by the police who responded to her 911 call. Well, in the criminal case, he pled guilty, and then he underwent substance abuse evaluation, counseling with AA, and he was involved with lawyer assistance. The commission now in this case was also split. One wanted a reprimand, two wanted 30-day suspension, I think two wanted a 90-day suspension. In the case, in the hearing, the lawyer said that he had an alcoholic blackout, could not recall anything. His girlfriend, who did call 911, testified that she could really not remember because she too was drinking heavily. So the court entered into an extended conversation or discussion about private conduct and whether discipline is warranted when the practice is not effective. The court, however, found that his conduct did reflect adversely on his fitness to practice. The court made a point of saying that a lawyer doing family or criminal law may not recognize a client's behavior and adequately represent clients if he doesn't recognize the seriousness of his own behavior. So the court issued a 3-month suspension. There's a discussion about prior precedent, both where maybe it had been too severe or not severe enough in punishing domestic abuse cases. The court always entertains what are aggravating and mitigating factors. In this case, the injury to the girlfriend was aggravating. The mitigating circumstances were that he really had made a robust effort to address his drinking problems. This next case that's in your outline or your slides involves a judicial magistrate. As I said, I'll come back to that hopefully later. It did involve a question of a magistrate actually making private use in his practice of files in the clerk's office that were expunged, and he used them to impeach a witness. But we'll try to come back to that. One of the big cases of the year in terms of interest and also number of pages in the decision involved a lawyer by the name of Larry Stoller, and this was handed down in May. Actually, the case came down on the same day of a civil decision, a civil appeal involving him. It's complicated, but I'll try and keep you on track with it. He was charged with 2 counts of conflict of interest. One involved his representing the lessor of a restaurant property. The lessee corporation had 3 owners. The lessees defaulted and they abandoned the property, or so it seemed. In any event, the lawyer set up a new corporation for one of those 3 owners of the lessee company. He then prepared a new lease for his client, the lessor, including the use of the equipment. And then he prepared documentation where the one owner, the new corporation lessee, gave that equipment to the lessor to pay for back rent that was still owing. Well, of course, the other 2 owners of the lessee found out about this and they sued to recover their equipment. The district court looked at the transaction and found that there was a sham transaction and set it aside. When the lawyer prepared the new lease and the equipment, he should have known that this is what the court said, that the one owner, his new client of the new corporation, did not have permission to do that. In the outline, you're going to see a couple of slides here which, due to cutting and pasting, appear to be duplicates. There are a few duplicate lines in there. In this situation, the lawyer tried to get a waiver of conflict between the lessor and the lessee after the fact, and the court held that you could possibly do that, but not where the parties are not given independent counsel, or at least advised to go get independent advice. So it was, in essence, a good attempt, but failed. The second case that he had on a conflict, he represented, I'm going to call it Client A, on various matters. Client A on its own negotiated the sale of its business to Company B. The lawyer was not involved. The lawyer then representing Company A on a small claim against an unrelated third party. There was a trial and the decision was pending. While that case was pending, the lawyer assisted B, the buyer of A's business, to get A to deliver a deed on the business sale. So he's now representing the buyer of A's business. Well, this case was found to be a conflict. Both cases were conflicts. In the first case, however, there was a great deal, according to the findings, of misrepresentation and deceit. And so it was a concurrent conflict because he was representing both sides of disputes at the same time. In the second case, while the small claim was pending, the lawyer actually threatened his first client, Client A, with litigation in order to get that deed. So that while this was all going on then, of course the small claim decision was adverse to A, and the lawyer advised it to appeal. So that case was still alive, so to speak, and while it was pending, the lawyer now actually files suit against his client A on behalf of B. So in the case, A asked to have him disqualified, and the district court granted that motion. He appealed that disqualification to the court, and if you read both the civil appeal and the ethics appeal, you'll see that he lost both on the same day. With regard to the conflict, the court found multiple rule violations on a concurrent conflict, and the commission recommended a 3-month suspension. The court went through an extensive analysis on concurrent conflicts, and said in this situation that there were directly adverse interests of the clients, and he could not represent either one of them adequately or fully. And when you have that, that's a concurrent conflict. It just could not represent both. Even in this case, the court said you might sometimes cure a conflict, but they again have to be independently represented or independently advised. At the worst, this lawyer, at least this lawyer should have attempted to document his efforts to get a waiver. Again, the court in the first case agreed that it was a sham transaction. He knew the owner did not have authority to convey. In the second case, if you read all the facts, which are voluminous, the court was troubled by the threatening of the lawyer's client A at the same time representing client A. The suspension might have been longer in this case, but the court did not find any misuse of any confidential communications in representing both. And the court accepted that he did advise client to get separate counsel. Saying that the primary goal is to protect the public and not punish the lawyer, which is in almost all these decisions, the court upheld a suspension. The lawyer is pretty combative with everybody, and it did cause delay in the litigation, and it caused extra attorney fees. So those were aggravating factors. The mitigating factors is the court found this lawyer suffered from depression, and after he got involved with the grievance commission and the board, he had come around. He was now assisting other lawyers and dealing with their depression. He also had a long practice without any recent discipline for any kind of related misconduct. So those mitigating factors helped him avoid a longer suspension than the 60 days that the court gave him. There's a note in this case that the commission was concerned with evidence that he had been brandishing a firearm in his office, but the commission would not consider this because it was not part of the board's complaint. You'll see more and more cases involving due process concerns where the complaint may not set forth everything that the board gets into evidentiary-wise in the hearing. And there have been cases where the court has actually reduced the suspension or the discipline when the commission adopts findings of misconduct when there wasn't adequate notice contained in the complaint. This next case involving Mary Howes, Judge Howes, is a pretty extensive case. I will try to come back to it. Suffice it to say right now that she was a litigant herself and had her client appear in front of her and issued an order for her in a TRO case, a custody situation, a temporary restraining order, while her case appeared to be actually being still litigated. So her own lawyer appeared in front of her. We'll try and come back to that. As you can see from the slides, it's very involved. And the next matter is also a judicial qualifications case involving a part-time magistrate, which I am going to also skip over, except to tell you that this lawyer maintained a website where he appeared in his judicial robes and advertised that he was available to do weddings. The court found that that was improper, and he wasn't disciplined because he resigned his post before the case went to submission. Again, we'll try and come back to that if time permits. Now, a big change in the rules in 2016 involved whether or not lawyers who are revoked can ever get their licenses back. And in years past, there was no rule on that. It could be done in exceptional circumstances. But in this case involving Mr. Reilly in September, the decision extensively goes into the history of the lawyers getting revoked. He'd been revoked in 2000 for misappropriating clients' monies, $137,000. He had a gambling addiction, which was documented. His license actually wasn't revoked until 2006, but he had taken the money in 2000. It wasn't fully prosecuted until 2006. Commission in that case was only asking for a 3-year suspension as the monies had been returned to the clients, and it would seem to be an isolated event. So in 2009, the lawyer applied and sought reinstatement. But at that time, without this rule, the court just found he had not carried a burden to show that the need for permanent revocation was debatable, and if he had undergone reformation. In other words, it had to be non-debatable as to whether or not he should no longer be without a license. And at that time, the rule did not provide for much more than putting the burden on the lawyer to show no need existed for him to be revoked, that he was no longer a possible harm to the public, his clients. But in 2015, we got this rule amendment. Mr. Reilly applied in November of 15. At that time, the disciplinary board resisted, and the Board of Law Examiners also reported against readmission. The examiners did so because the reports that were filed about his having his addiction under control were old reports. So there was a hearing, and then the court ordered a review by both of these boards, and they wanted him interviewed. So after that was done, the disciplinary board continued to resist his application, but the law examiners, majority of them, 4 of 6, favored his being reinstated. They found now that he was in control of his gambling, and he had satisfied them that he was of good moral character. Well, the court heard the reports and considered his application in full and found that he satisfied the new rules, which require that the lawyer show that he's of good moral character, he's fit to practice, he's complied with the terms of his revocation order, which would generally be a misappropriation case, and of course the minimum would be that he had to repay any monies taken. The proof of good moral character and being worthy of readmission is generally going to involve not only his own statements, but giving affidavits. He had provided affidavits from practicing lawyers. He also showed that he had never cost the client any money because it was repaid, and the client security never had to pay anything on any kind of claim against that fund. In his time, when he had his license revoked, he had been working as a mediator, a consultant to lawyers doing claims work, and to claims adjusters. And through this, he had kept abreast of the law. So the court cited the model rule from the ABA, which has 6 main factors, very similar to what the new court rule has. A big question there is really the lawyer has to demonstrate some candor and sincerity about his good character and his remorse for what caused him to be revoked in the first place. You could also show anything that would bear on fitness, and despite the disciplinary board's opposition, the court found that he satisfied the factors and ordered readmission, conditioned upon him taking 30 hours of continuing ed and 3 hours of ethics. He had to take the ethics exam and score at least an 80, and he had to secure and keep malpractice insurance. Also in September, there wasn't a lot going on until September, at least with the cases that were filed. And if you think about the total number of cases filed in this year, it may seem light. I'm told by members of the board that will probably change in 2016. There is more work in progress. In any event, in September, another case came down involving the lawyer Deborah Johnson. She was a sole practitioner, and she had admitted to having a sexual relationship with a client who she was defending on numerous civil and criminal cases. The client went to prison. She continued to have contact with him on the phone, as detention officers monitor phone calls when people are in corrections. Her phone calls led them to believe that she had a personal relationship or a non-professional relationship, and it got reported back to the county attorney who was prosecuting. He contacted this lawyer and spoke to her about not representing this inmate. She admitted the relationship and agreed that she would withdraw from representing him. She then self-reported. At least it was said to be self-reporting. The board got the complaint on her report and filed the case with the Grievance Commission. There was a stipulated decision, or they stipulated anyway, that there was no need for a hearing. I recommended a 30-day suspension for a sexual relationship rule violation. There was also a charge that she interfered with the administration of justice. So even though this was all stipulated to, the Supreme Court, on reviewing the matter, accepted the 30-day suspension, but did not find an administration of justice violation because there were no additional delays or difficulties caused to the court. There were no dismissals involved, no rehearings, that kind of thing. In essence, the court said a sex relationship is not an automatic violation of the rule against interfering with the administration of justice. Important to note, you'll find these in any case dealing with the lawyers having sexual relationships with their clients or staff. Sexual relationships with the client is never consensual. The basis of that being because the relationship is not equal. And there was just no question in this case that it wasn't consensual by rule. However, the court did not believe this case was as egregious as there have been in many other cases. But a big aggravating factor is that when this occurs in a case where the subject matter, the client, is criminal or family law matters, clients are most vulnerable in those situations, and that does make a situation more egregious. Her mitigating circumstances were that she had no prior disciplines, there were some mental health issues that contributed to the conduct. The court did note, however, that her self-report really only came after the FBI confronted her about the client's serious ongoing offenses. The next case in September involved a lawyer by the name of Sheree Smith, another sole practitioner, and I have to say, unfortunately, most of the ethics cases we see seem to involve sole practitioners or small offices where there is not enough oversight or someone to make the lawyer accountable, and it's typically being accountable for one's trust account or follow through with client commitments. But in this case, Smith had gotten a retainer in February 2012. She did give the client a fee schedule, but it wasn't until July that she filed the requested temporary restraining order application, and then she continued it indefinitely. She withdrew the fee in total, but never notified her client. In October, the client hired a new lawyer who asked Smith to withdraw and return or forward what was left of the retainer. She never responded. The client then complained to the board, which asked for an explanation. Smith said that, well, she had exhausted the retainer, but she never responded to any of their requests about why she did not respond. So there was a trust account audit, almost routine in these cases. The auditor found that she had commingled funds. She did not deposit all fees in the trust before they were earned. She did not promptly return unearned fees. She did not return papers when requested, and she did not keep adequate records. Now, the board and the lawyer then stipulated to the facts in a 30-day suspension. The commission held a hearing. She said she wasn't keeping records because her computer crashed and she lost records in the flood of 2008. The commission had recommended a 2-month suspension, even though there was a stipulation for by the board and her for a 1 month. The court accepted the case, the recommendation. It said that taking fees without compliance was admitted, but the court was not bound by the stipulation on anything. And as far as the record problems, it said, well, that there may have been lost records, but there could not have been any problems with the computer or the flood, because the records in this particular case would have all been created long after the computer supposedly crashed and the flood. So the factual allegations were established by the stipulation, but the sanction request, she did have 3 previous admonitions about trust account deficiencies. The court said that she was making numerous attempts to blame other people for her problems, not taking responsibility. She also used her trust account as her general operating account, even put her tax refund in there, personal insurance settlement matters, or monies. and took out cash as opposed to using checks. And the rules require checks so that you can track monies from trust. So the court went with the board and gave a 60-day suspension, primarily because this was a problem similar to what she had been previously admonished for. Again in September, the case involving Kenneth Weiland, another sole practitioner. He had trust account violations and not being diligent with the client. This is a one-case situation at this time. In March of 14, he was retained to file a dissolution. He had a $1,000 retainer paid in a couple of installments. In March, the client signed a petition, and he attempted to file it with EDMS, but never got it done. It was never accepted. And he did not do anything to get that corrected. Meanwhile, he told the client that 4 months were passing because the sheriff was still attempting service. By August, the client was tired of waiting, determined on her own research that there was no request in the sheriff's office and the petition had never been filed. The client mailed a termination letter to the lawyer and asked for her fee to be returned. The lawyer did not respond for months. Meanwhile, for whatever reason, he did get the petition correctly filed and even got a pretrial set. However, neither the client nor he showed up. Of course, the client was never notified. So the client got a new lawyer and complained to the bar, or the board. I dated myself there. The board then filed with the commission, and the court found that the lawyer had no contact with that client until the day of the hearing and did not return the fee until the day of the hearing before the commission. The lawyer simply said he did not know how to operate or how to correct the EDMS error, and did not want to admit to the client that he made that mistake and didn't know how to do it, and he just did not respond. He froze up. Sometimes humorously, people who do this work will call that lexaplexy, kind of a legal paralysis. And it's true in many cases. Lawyers hate making mistakes, and they also hate explaining them or admitting them. And that failure to be able to admit it can get expensive and embarrassing. Well, the court found that he wasn't diligent and he misrepresented the status of the case, made an improper use of the retainer, failed to withdraw, failed to refund, and he did interfere with the administration of justice because of the delay and the refilings that were necessitated by his neglect. It was aggravating in this situation that he had previous admonitions, a reprimand, and suspension, so that justified a 60-day suspension in this case. Might have been longer. The court found mitigating factors were that he indeed was sincerely remorse or had remorse, and he serves a low-income clientele, a factor frequently present, unfortunately, with several of these other sole practitioner cases. Katherine Barnhill, also in September, received a recommendation from the commission for a 6-month suspension. She had been sanctioned in the district court over a fee dispute, also in the federal district court in connection with the manner in which she represented a client and herself. In the fee dispute, the lawyer represented a client on an hourly basis concerning a $20,000 mechanics lien on his house. It got litigated. She billed him over $60,000. The client paid it, but went to the fee arbitration committee. It only awarded him 25% of the refund, and the client was ordered to pay the money. The lawyer paid $1,000, but then got suspended in another matter and stopped paying. She said she stopped paying at that time because it might appear she was practicing law. But she made promises to pay within the next month or week, and those promises were never fulfilled. Eventually, the client got a new lawyer who gave the Barnhill 2 weeks to make the payment or else. She responded by promising to pay, but she wanted a global release, which included not filing any complaints with the board. That's obviously a no-no. So she also threatened to sue the client for continuing conduct without explaining what that conduct was that would create a cause of action. So the client wasn't paid and sued. The lawyer, Ms. Barnhill, counterclaimed, claiming she had paid in full, and she then also, in her counterclaim, or cross-petitioned in the client's new lawyer. There was a bench trial. The court found the client, or found Barnhill, not to be credible in the lease, awarded judgment, attorney fees, and sanctions. Sanction of $5,000 was awarded for not paying an undisputed debt and filing baseless counterclaims. Meanwhile, in the federal court, she had filed a negligence case and was late filing expert designations. She did not respond to discovery despite being ordered twice to compel. Summary judgment was entered against her, and the court sanctioned her and the lawyer, her client, as well. In those hearings, the court found that she had made several false statements concerning the delay in responding to the motions to compel, orders to compel. So the court awarded $30,000 for litigating discovery disputes that were frivolous, also awarded a $20,000 sanction because the entire suit was found to be frivolous. Her response to the board was that she paid the client the fee that was ordered to be rebated. And she told the board that this case would be dismissed on summary judgment in her favor, meaning she'd get a summary judgment out of the commission. That did not happen. The board charged her with making frivolous claims, false statements to the court, false statements to third persons, the disciplinary board, and she engaged in dishonesty, deceit, etc., all prejudicial to the administration of justice. The commission found all the charges established, recommended an indefinite suspension not less than 6 months. She appealed, but then did not pursue her appeal, and in doing so indicated to the court that she may retire from the practice. She never turned in an affidavit of disbarment as of the date that the case went to decision by the Iowa Supreme Court. But that indication to do that was apparently considered by the court in its decision. The PowerPoint slide says commission decision. Really, it's the question of retiring was in the court's decision only. Well, because this case was not tried on a fraud standard in the district courts, the decisions were not given a preclusive effect. And if you think about the rules, if a lawyer commits something for which they get sued, and the case is tried such as on a fraud standard, which requires clear and convincing evidence, that decision can be preclusive in a disciplinary case. Her cases were not tried on that basis, but the court found there was still plenty of substantial evidence supporting both final orders. So the court upheld the commission findings and then some. Interesting point in this case, there were false statements made to the opposing lawyer, and the court found that false statements made to opposing counsel can violate the disciplinary rules and provide the basis for being disciplined. Well, despite previous serious misconduct, similar misconduct, the court ordered a suspension of 6 months. It seemingly gave weight to the communications about her retirement. I say that because when you read the case, it appears that there was a consideration for revocation, and one has to assume that her signal that she may retire saved a revocation at this time. Maybe more on that later, who knows. There's a public defender case in the outline. It's interesting because it involves a lawyer's effort to comply with rules and a district court judge charging the public defender fund with expenses because the judge felt the lawyer didn't act fast enough. I'll try and come back to that. It's a good read, but not necessarily, it's not a disciplinary case per se. In November, a big month, there were about 4 cases decided in November, and I think all on the same day. This first case, which would be lengthy, involved lawyer David Morris. He had a hearing in front of the commission. The commission recommended a public reprimand. He appealed that, and what used to be fairly frequent, the court actually issued a suspension of 30 days. Well, in this case, the client represented a home builder who was contesting mechanics liens on a couple of his properties that he built. There was a written agreement with the lawyer and the client that he could offset any fees owing against any monies in the lawyer's possession. The client refused settlement opportunities and lost at trial. Considerable difference between what he was advised to settle for and what he lost. In any event, there was a discussion about that outcome, and the clients chose to appeal. The lawyer asked for a retainer and pay the transcript cost. The client said they'd do that. They also still owed over $2,800 for trial fees. So the dates are only important to show a couple of particular aspects of this problem. The appeal was filed on August 8th. He paid the filing fee and represented that arrangements were made with the court reporter. However, there was no contact with the court reporter. And the client only paid part of the fee and did not pay the transcript cost. So by August 30th, the client was telling the lawyer that they had problems which prevented them from paying the fees to the lawyer and promised to pay by the 10th of September. That never happened, unfortunately. By December, the court gave notice that the transcript was overdue. When that happens, the court reporter gets notice of that. The court reporter immediately advised the court, well, there was never a request made. The lawyer then wrote the court reporter. The court reporter reiterated, wanted $1,400 before beginning, and it would take 40 days to do that. The lawyer wrote the client telling that you owe $1,400. The court, however, told the court reporter, ordered the lawyer, to pay the court reporter within 10 days. A couple days passed, the lawyer wrote the client again saying he would not advance the fee, the expenses, and that the client should send him a check payable to the court reporter. That did not happen. A couple weeks later, he wrote again. The client was having problems, put up excuses about not paying. Finally, on 4th of January, the lawyer got a check for $1,400 and one for $500, both made payable to him, contrary to his directive. So the lawyer wrote the court reporter, said the check was forthcoming. However, he put it in the trust, but he did not ask the court for more time to get the transcript. On the 10th, the appellee moved to dismiss the appeal. By the 14th, the lawyer knew that the $500 check was returned for insufficient funds. On the 18th, he filed a resistance to the motion to dismiss. He said that the client had not paid the costs. He acknowledged that he had gotten the check payable to him and deposited the trust, but still did not ask for more time and never forwarded any money to the court reporter. He did then tell the client he was not going to represent them. He asked the court for time to get replacement counsel on the appeal. There was communications going on with the client about the case. The client then started asking the lawyer about, well, where's our $1,400? The lawyer said, you were supposed to have paid it to me or to the court reporter. I'm waiting to see if it bounces like your $500 check. Unfortunately, in the midst of all this, client made more promises about paying. That never happened. The lawyer did get a check from his bank to pay the court reporter on the 31st of January, but that never got mailed. By the 8th of January or February, the client paid another $1,000, but was telling him he would not proceed with the appeal. Still was not paid in full. On the 21st of February, the court dismissed the appeal. On the 27th of February, the lawyer told his partner to endorse the $1,400 and deposit it for fees. The client then started demanding refund of the $1,400. The lawyer refused to pay that until the $1,725 was paid. What it apparently is not in this findings of fact is that the client was telling the lawyer, which I understand from the record, send that $1,400 check back and then the client would send the lawyer another check. The lawyer said, no, I don't want to do that. In any event, the client was mad because the case was dismissed and the appeal was done. It was over. Never got a hearing. The lawyer said, well, I have a right to a set-off under our fee agreement. I can offset those $1,400 that you sent because of my fee agreement. The client said, no, pay that $1,400 against these judgments that I have. The lawyer did not do that, but did assist the client with all the paperwork to satisfy the judgment when the client paid it to the judgment holders. But the case went to the board. The commission found violations for the lawyer not being diligent, for not safeguarding property, and for interfering with the administration of justice. The court accepted those findings and found that the lawyer knew that the $1,400 was to pay the transcript, and it had time to determine whether or not that $1,400 cleared the bank before the appeal was dismissed. So the question about the fee agreement and the $1,400 offset, the court said that the express agreement to use the $1,400 for special purposes trumped the fee agreement. In other words, the $1,400 was known to the lawyer to be for the transcript. That's called a special purpose. And even though there was this express fee agreement, the court said, no, once you got those monies and they were designated for a special purpose, you had to use them for that purpose or refund them. In this case, there was a dispute about what to do when there's a dispute over monies held in trust. And the essence of the finding is that the lawyer cannot take monies out of trust until that resolution is attained. And you can do that either by going to the fee arbitration, by having a hearing in court, having private mediation, but the lawyer's got a duty to let that client know that there's a way to have a third party resolve this dispute. You just can't sit on it or decide for yourself that you're entitled to it. In this situation, the lawyer had some private reprimands. He had been in practice for a long time, which I actually found to be an aggravating factor in the sense that perhaps he should have known better. This case is particularly interesting. It should be in your notebook, maybe not so much for the majority opinion, but for the concurring opinion and the dissent. The dissent by Justice Wiggins criticized the court's philosophy of having legal stealing versus illegal stealing. The concept of having a colorable claim to monies that the lawyer takes out of an account has been used to avoid revocation. So if a lawyer, when he takes monies that the court finds were misappropriated, if he can make a strong case that he thought he had a right to take those monies, that might result in a suspension but not a revocation. The court, Justice Wiggins, called that legal stealing and thought that it's time to change that. And his method of changing that would be to adopt the ABA model rules for measuring sanctions for conversion of funds. And if you read this case, you'll see an extensive discussion of what elements go into there being an objective basis for suspensions versus revocations when funds are involved. He clearly would have done more than a 30-day suspension if the model rules were followed. The concurring opinion agreed with that idea that it was time to get away from illegal stealing and go to an objective basis, an objective standard. But because the idea of something more serious than a admonition or a reprimand was never presented in the case before the commission, felt that that would be a denial of due process and wanted to stick to the claims and sanctions contemplated in the complaint that was filed by the board with the commission. So the lawyer got a 30-day suspension. In the Arsberger case, Sole practitioner had an executor of a will client and told that executor that the fees would be, for ordinary services, would be $220 plus 2% of anything over $5,000 in the estate. And there would be extraordinary fees for certain things. Well, it ended up there was a will contest with the decedent's girlfriend. The lawyer was defending that contest. It became evident she was going to be a witness, and so she got consent to the court to hire another lawyer to help with that trial and the hearing. They were successful in the hearing, defeated the contest, but then the executor got billed for extraordinary fees. There was no approval of fees by the court. There were no fee affidavits filed, just that the executor was billed. Over objection, the lawyer paid part of the fees to the Arsberger and then paid the fees to the second lawyer. But the executor was unhappy with the fact that the lawyer was billing for about $2,600 of fees incurred after the new lawyer was hired. Did not think that was necessary. This lawyer spent a lot of time trying to get that lawyer to explain to him why the bill was the way it was, and was asking for some way to get this dispute resolved. The lawyer never gave a way of resolving the dispute, such as filing requests for approval of fees with the court. And she also told him that the court had approved the bills, which was not true. So eventually, the lawyer had the final paperwork done and closed the estate. The closing papers, the report, and the order recited that the executor was waiving a hearing on fees. Well, the executor never questioned the ordinary fees because the lawyer had told the client that it would be 2% of anything over $5,000. So the estate's closed with the matter of extraordinary fees still being unpaid. And she contacted the lawyer or the client. She wanted to get paid. The executor paid, but he filed a complaint with the board. The Grievance Commission got this case on stipulations, ordered a refund on stipulation, or actually get court approval before doing that. In the hearing, the lawyer offered that she thought application had been made for court approval on the extraordinary fees. However, she could not find any paperwork of those documents. The commission found she was not credible and that she intentionally did not respond to the executor's request for a way to resolve the dispute over the amount of fees. Again, if you got a dispute with a client over fees, particularly if they're in trust, you've got to get a third-party resolution. In this case, it would have been simple to ask the court, the probate court, to approve the fees, which is what the rules require, before taking the second half of the fees. That was never offered to the client. So the commission found, and the court agreed that the fees charged were unreasonable, and the violation was there for not advising the court or the client of how to resolve the problem. There was a 30-day suspension ordered in that case. We're not going to get through all of these, but I want to talk to you about the Taylor case. The Taylor case, the client had not, or the lawyer had not filed tax returns for 10 years. She got divorced in 2010, and the decree required both of them pay separate returns. She had not filed her returns before 2014. In 2014, this is where things get sticky sometimes. The lawyer told her ex-husband that she was considering seeking modification. She wasn't happy because her relationship with her children was being allowed to deteriorate, she said, due to her husband. Well, the husband had a girlfriend, and the rest of the story is the very next day the girlfriend reported this lawyer to the board for not filing her tax returns. There was a stipulation by the lawyer to all the facts. She admitted knowingly failing to file returns. She had substantial income, but she had a dysfunctional marriage. There was no question that her actions were criminal. but there was never a criminal case filed. By the time of the hearing before the commission, she had filed all the returns and was negotiating a schedule for payment of the taxes. Because these taxes went back to 2002, which was under the old ethical rules, the court found that there were violations both under the old rules and the current rules, that non-filing of tax returns reflects adversely on one's honesty, trustworthiness, and fitness to practice. The court recited the rule that you don't need a criminal conviction to sustain a disciplinary complaint. And the failure to file tax returns, particularly under these circumstances, constituted fraud, deceit, and misrepresentation. The commission had recommended a 30-day suspension. The court discussed that this could have a range of anything from a reprimand to a 3-year suspension if you follow past precedent. The court, however, heard the board ask for an 18-month suspension against the commission's request for 30 days and issued a final order of a 6-month suspension, and she had to show compliance that she was, or proof that she was complying with the tax payment schedule. If you look at the slides, you can see the Pederson case. It involves another sole practitioner getting suspended for not timely serving the client contrary to the agreement. And in the probate situation, she took a fee, second half of the fee without court approval and in the wrong amount. Her situation was really peculiar. The court removed her from the probate case and her client, the executor. And she was ordered to repay, both of them were ordered to repay $29,000 of fees each. She had no money. She borrowed the money from her client, the executor. No written agreement, no independent counsel. So she was eventually disciplined for taking the fee in violation of the probate rules, not following through with completing the work for the domestic relations case involved, and then for doing business with the client and having a conflict situation because she did not get independent advice for the client. The Green case, the last case, just going to tell you, this lawyer got revoked. The cases involving revocations are always the shortest because usually there's just no defense, not even a colorable claim of future fees in this situation. And you'll have to read the case for yourself because we're out of time, but keep abreast of this development. In the Green case, the court starts, in the dissent, was reviewing what had happened in the Taylor case because the court in the dissent wants to see the ABA standards for revocation adopted, what they call objective standards, so that you get more consistent results from case to case as opposed to the individual study that a court does in every case, particularly on the question of sanctions. Every case, every opinion has an extensive discussion of what is an adequate or just sanction. So in cases involving misappropriation of funds or fraud and misrepresentation, Justice Wiggins is really adamant that there's got to be an adoption of a more objective standard. Christy, I know we've pushed the time. Are there any questions?
No, there were a couple people that wanted the outline for the assignment, so I resent that out to everybody.
Okay. Well, with that, I thank you.